Okay. Oh, we're live. All right, great. Hello. Welcome to the very first live stream on Legal Bites. Super excited to have two great friends here, also YouTube lawyers. We have, of course, Nate the lawyer, and we have Kurt, also known as Uncivil Law.
Woot.
Thanks so much. Thanks so much to you guys for joining me here. You guys for the last couple of weeks have had me on your channels for this very live stream, and I'm super grateful to be joining you guys. I've been watching your stuff, like I said before. I've been watching your stuff for months now, and so I'm so humbled and I'm so honored to be able to join with you guys. So anyway, so how are you guys doing?
I'm having a good one.
Yeah, I'm just working and doing the Chauvin thing, and I've been doing the live streams in the daytime, so it's been a little busy but it's a good thing because it's when things are happening, it's busy, and it makes the time go by a little faster. You know what I mean?
Yeah, absolutely. So yeah, every week seems to go by pretty quickly. So, yeah. So I guess the first topic that I think everybody is really thinking of these days is the Chauvin trial. So we've been talking about it the last couple of weeks as well. And so yeah, we should talk about what the latest is from the last week. I mean, there's obviously been a lot of expert witnesses. The prosecution has put on their case in chief. The defense is now putting on their case in chief. So Nate, let's start with you. What are your thoughts on the let's just say the expert witnesses so far?
No, I think on both sides. I think on the prosecution side, I think the experts were entertaining. They seemed to know their stuff, and I think Kurt saw my live reaction. The defense attorney's cross-examination of the experts, I think, left a lot on the table because he was letting them explain a lot of stuff. And as lawyers know, if you're explaining on cross-examination, the lawyer's doing a bad job. That witness is supposed to just be saying yes, no, maybe so. That's it. Nothing more than that. As soon as they start saying, "Let me tell you a story," no speeches on cross. That was a yes and no, sir. So that was one of the problems with the defense, and Kurt saw that live. The second thing is we're talking on the defense's experts. They were good in the sense of they said what the defense wanted them to say, but they were bad when they were pushed for details, because that seems to be their problem. And even the use of force expert had to make some admissions, and the ME had to make some admissions here. Like he's saying, I see pills in the mouth, and later on cross, it's like, I never really said they were pills, and this, it just whenever your expert's getting caught up, it just doesn't lend to them that credibility. And the only thing I would say, especially with experts sometimes, is that it seemed like the defense experts didn't want to concede simple points, right? Like, was Floyd unconscious? And it's like you had to struggle to get that. Well, maybe so. If somebody's three people with their knees on your back, is that painful? You got Floyd neck cramp with the neck in his neck. Does he look like he's in pain? He could. It's just like you gotta. If it's something that we can all see, just say it, because it kills the damage, and then hopefully on redirect they'll help you out. But here it just seemed like they were trying to fight too much on cross, and the cross examinations were brutal. So I think at the end of the day, if you're talking about who won the expert battle, it looks to me like the prosecution did.
Kurt.
I'd have to agree so far. I feel like the defense case has been lackluster and doesn't feel well put together. I was surprised with their initial witnesses that they felt like they could have done more with them. This other arrest video that was happened, they could have gone into some more details about the nature of that or similar incidences, to go into how this is a normal part of their policing. Have you seen other instances that are familiar? This is a familiar sight. Did this behavior surprise you in some way, to play up the idea that this is part of the noise of the normal? People are resisting, people not following directions, people making claims. So I felt like they could have done more with some of the initial witnesses. They didn't really get as much done with them, and I thought that was a missed opportunity. I agree with Nate that the witnesses that have been on the defense have been too clever by, well, the normal expression is too clever by half, but that's not quite fair. So let's say they're too clever by an eighth. They're being a little bit too zealous with what they're saying, and that's catching up on them. The expert who said, well, Mr. Floyd, if he wasn't resisting, would be lying comfortably on the ground.
Yeah.
And the prosecutor just said, like, on cement? And it's like, and they're like, oh yeah, that's right, I look like an idiot. Or the same expert who I believe said when he was on top of them, that isn't use of force at all. And every single person in the room is like, I kind of think it is. Kind of think if the officers are on top of me and they have their knee on me, that might be some version of force. For that matter, as Nate pointed out in an earlier stream, if the cop is just there and he's just talking to me and he's armed, there's force implied. So it's like there's force implied in this continuum. So they've been a little bit too clever in some of their statements. Felt like they haven't been able to get as much as they wanted from. Am I correct in understanding that they think the defense case might be done by the end of this week?
It's supposed to be done tomorrow.
Yeah, that seems amazing to me. It seems amazing to me that the prosecution's case went on forever and a day, and the defense's case is going to be so comparatively short. I'm surprised on a whole number of things, because I mean there must have been motions in limine out the backside, but I'm surprised that as many people testified for the prosecution as they did. It's like, do we really need that 8th police officer and 6th use of force guy and so forth and so on? And the defense over here is like, well, we're done in 4 days, and then we'll take a long weekend. We'll start deliberating on Monday. I'm like, okay, well, this is weird. So I feel like the defense is not doing as much here. I expected a lot more from the defense. I'm very unsure about what the strategy is here. It seems like there's a lot of missed opportunities.
Yeah, definitely. That's definitely true. I agree with that.
Yeah. Well, I mean, as we know, of course, the defense doesn't technically have to really put on much of a case. All they have to do is poke holes in the prosecution's case. But I mean, that is a very good point. I mean, it does, when you're just looking from a layman's perspective, you would think that having so few witnesses sometimes can indicate that there's just not much evidence out there on their side that they would want to put forward. I mean, on the other hand, it could just be that they want to keep it tight, keep it simple, so that they have, less kind of fluff to include with their stuff, I guess, if that makes sense.
Well, that's what they're going for. It's not really tight, in my humble opinion. So if that's the idea, it's not really coming off that way.
Right.
But the problem. Well, go ahead. I'm sorry.
Oh, no. Go ahead, Nate.
No, I was just saying the problem seems to be is that, yes, it is true the defense has nothing to prove, but in reality, the defense does have a couple of things. You know what I mean?
Right.
Philosophically, yes, but I think actually no, because that you don't want that jury. If it was so true the defense had nothing to prove, they could have just said that's the end of our case. Let's go with the information the prosecution has. So I think they're trying to. Like today, just confuse the jury. That's what the defense attorney's job is. It could have been Chauvin, it could have been a knee, it could have been fentanyl, it could have been any of these things. But
could have been gum.
Could have been gum. Was it gum or was it else? But I think
gum with the meth and fentanyl. Double your refreshment.
But I think at the end of the day, people want to know why things happen, and juries want to know why things happen. And the defense, I don't think, did a good enough job as to try to. Right now, the why is Chauvin's knee. Everybody's saying that. The defense needs to make me think, why? I don't know why. And if you go into that jury room and those jurors believe they know why, then Chauvin doesn't have a chance.
Yeah.
Now, has the defense formally announced at this point whether or not Chauvin will testify?
No, he's not testifying.
Yeah, I didn't think so. I didn't think so. I didn't know if there was a motion on that or not. So. Yeah, I guess at some point someone's going to have to ask, presumably tomorrow, if the defense wants to wrap up its case.
Right.
Yeah. At some point, the judge has to be like, you have the right to testify, just to remind you.
Right. In case you didn't know.
This have to remind you for the record here. And it's your decision, and they can't stop you, even though they might really, really want to. So what do you think?
But some of the earlier expert witnesses, were interesting to see. I remember there was a big to-do about Dr. Baker, the medical examiner. It seemed like people that were more in Chauvin's camp were saying that his testimony was very helpful to the defense. When I was watching it, I didn't really. I mean, it opened up the door a little bit for the prosecution to point out some reasonable doubt. Because I remember he was talking about the position of the knee on the neck, that realistically that couldn't have that couldn't have caused asphyxiation, but the fact that he was restrained in the way that he was really ultimately the reason why he died anyway. So like that can introduce some confusion, I think, for the jury for the cause, but I think that they have probably enough other experts there to say, no, the knee definitely affected him. No, the fact that he had, he was pressed between a hard ground and, a human body on top of him meant that his chest couldn't expand, like all that kind of stuff. So what do you guys think about that?
Well,
didn't he also say something along the lines that if it were anyone else in Floyd's position, they also would have died? Or am I imagining that they said
that was the pulmonologist said? Yeah,
yeah. Someone,
even
one of the doctors said it's hard to keep track, and I found that to be a slightly odd statement. Because I'm like, I'm a layman. I have no particular medical expertise, so what do I know? But I'm like, I have a hard time believing that you can establish to a medical degree of certainty that basically anyone else in that position also would have died in the exact same situation. It's like, I'm not saying that there aren't other factors, because that would essentially mean that none of Floyd's factors are relevant to this equation at all. If it were you, me, or Alita here, we'd all be equally screwed. I'm like, I'm not sure if I buy that.
Right.
Yeah.
I mean, because some people just have better lung capacity because they've been, training with a lot of cardio, for example. Like some people just take in more oxygen with each breath because of that.
Yeah.
So, I mean, and he had an enlarged heart. I mean, and for the prosecution's case, it's really, I mean, it doesn't matter that he had all of those factors that would have weakened him, because I mean, it's, there's a concept in the law that you take your victim as they come. Yeah. It doesn't matter how strong or vulnerable they are.
Well, I had to make that point today on my live stream, and it just was there's a case in Minnesota from the Minnesota Supreme Court called State v. Nunn, and in that it's a felony murder case, and in that case, the court says that at trial that it was found that the victim would not have died but for the assault, right? The assault killed, but a healthy person would not have died, but the victim in that case had a heart attack. Mm-hmm. So even though a healthy person would have survived, the victim and they were convicted, rightfully so, of felony murder. So here, even the doctor saying that, the only thing they have to do is just make that causal link. Was Chauvin, a substantial cause? Right now, you got an image report that's saying that. Right now, you got a pulmonologist. Right now, you got a heart doctor saying this. And on the other side, you got a doctor who's really talking about was a pill in his mouth or not. That's what I'm talking about. You got one side who's got world-renowned experts on each one of these pieces of evidence, and then the other side, you got a doctor who's a pathologist, but now he's talking about was there pills in his mouth? There had been pills in his mouth. Why are we talking about pills? We want to know what the cause of death was, and that's where. And even at that point, his cause of death was inconclusive. It's not like he's saying Chauvin wasn't even involved. So even if you give his thing credibility, Chauvin was still one of the causes of this man's death. And so I think it was a disaster in the sense, if you're really trying to throw reasonable doubt, that wasn't reasonable doubt. That was saying, well, I'm saying what everybody else is saying, except I'm saying it wasn't as much a cause. It was a little less cause. Okay, that still convicts him. I don't see how it does.
And
now continue. Sorry,
I was going to say, and correct me, if I'm wrong on this, because I haven't actually seen the last expert's testimony because of the time change for me. But that seems strange that an expert would be commenting on whether there was or was not gum in his mouth versus a pill in his mouth, because that seems like lay testimony. I don't understand why that would be something that an expert would be commenting on, because the whole purpose of having an expert is not to testify to what, where, when, how facts. Those are for lay witnesses. The whole purpose in having an expert is so that they can analyze the facts and then give an opinion, because otherwise lay witnesses can't give an opinion.
But understand the reason why this expert was trying to testify to the fact that he might have had a pill in his mouth, because they were trying to establish a 5-minute timeline from when Floyd took the pill, and supposedly in 5 minutes the effects of the fentanyl would have gotten to a point where he could have died from an overdose. So at that point, when you see a pill in his mouth, then you're counting for 5 minutes. So the pill became an issue, and the defense wanted to get the pill in. They couldn't get the pill into the use of force expert, but they can get the pill into the pathologist to say, well, yeah, he just took, he got a pill of fentanyl. 5 minutes later, he's dead. Obviously, was it the knee or was it the fentanyl? But I think he was kind of side slapped on the side when they said, well, look at him in the store chewing gum. Is that a gum? And then the expert himself went on and said, I am not saying that's a pill. I don't know what that was. It could be gum. That now blows up the whole pill thing. But I think they did recover well, though.
Yeah.
For me on the just the pure legal angle of it, like I'm always like, what is the best case for the defense? And I'm always trying to reassess what is the best case. And for me now, the weakest point of this is in the defense's argument of justification, because you have to concede that it's a assault in the first instance, because of course it is. You know, the officers, restraining him with handcuffs, so that's got to be an assault by any reasonable definition. But it's a justified assault because of legal authority that gives you the legal justification. So that's why it's justified. Now the justification 101, you can use justification if it's imminent or ongoing, but not if it's over, not if it's complete, not if it's finished. So if the use of force is imminent or if it's ongoing. So as long as he was about to resist, as long as he was resisting, but not once he stopped resisting. Now, what makes that a little bit challenging here from a purely legal perspective is because this is all one continuous event. There's no break in the event that you can say, well, he had any sort of break at all. It's just one continuous timeline. So it's like the challenge for the prosecution, and I don't think they've actually really satisfactorily done this, is to say, where did the justification actually stop? Because I think they have to concede he had it in the first instance. And if they're saying he didn't have it at the end, then it's like, where exactly did it stop? And more to the point, not only from a purely legal theoretical framework, but his ability to perceive it becomes important, that he would be able to do that. Because in order for them to get to the criminal intent, the justification would in fact have to elapse. He would have to perceive the lapse and then say, well, I don't care, I'm going to keep going anyway. And I feel like that, from a purely legal standpoint, has not been as well done as I would personally like. But I'd like some commentary from you guys.
I don't know. I'm thinking about the issue, because it all comes down to what is the legal standard, right? The legal standard, we're talking about Graham v. Connor, Supreme Court case, and that establishes use of force across the country, right? In the state level and on the federal level. And here in Minnesota, they use Graham v. Connor. And when you use Graham v. Connor, the standard is what they call objectively reasonable standard. And what that means is that what Officer Chauvin's intent means nothing. It's his knowledge, what his knowledge means, because you take his knowledge and you do what they call the reasonable officer test. Would a reasonable officer facing the same sort of circumstances in his position do the same thing without the benefit of 20/20 hindsight? With that, I think you're right. I think, and the witnesses even said it, their experts all said it. They were legitimate in using force at the beginning. But any reasonable officer who's trained here in the United States and is trained in Minnesota also knows that just because you use a higher level of force when the incident starts doesn't mean you get to use the high level of force at the end. The common example is I run to a thing, I'm in a shootout with a bank robber, and that bank robber throws down their gun, puts up their hands and say, I give up. I can't still continue to shoot, right? So force is actually proportional to the level of resistance. You can only use as much force as necessary to overcome the resistance of the suspect. That's the basic principle of it. So if you have a suspect who's resisting, I can use more force, right? Because I can use more forces to overcome the resistance. That's what the state allows me to do. But when the person stops resisting, then I'm supposed to change my level of force because the person stops resisting. Now, even in this case, what the prosecution, I think, have done is establish that Floyd was resisting at the beginning and the use of force was appropriate at that point in time. But there are a couple of key steps that I think the prosecution did put out there which I think legitimately leads to conviction. Number one, his pulse was checked. And you had an officer check his pulse and say, I don't feel a pulse. I think a reasonable officer,
I think that's right,
hearing that the guy doesn't have a pulse, that would let me to believe, like, hold on, we may have a problem. The second thing is the other officer said, I think he's passed out. That would, if you're passed out, then you're not resisting. That's the reasonable officer. Now, the other officer
saying we should check him, we should
turn him over.
All the rest of it.
Yes.
Yeah. Which incidentally is part of the reason. This is part of the reason I'm not on board with the accessory charges for these other officers. I'm not on the accessory train. No, it's not fun for me.
So we're talking about no poles, handcuffed,
Yeah.
not responsive, not moving, and he's saying don't do nothing. We're going to keep him right here, the same level of force you're using when he was resistant. That seems to be unreasonable. But then even the crux of that, even at the point where you say, okay, this force is unreasonable. The point I think with that convicts Chauvin is, even if you agree that his level of force used at the beginning was reasonable, I don't think anyone could agree that you can use that same level of force on literally a dead body for 4 minutes without giving him any type of care. It's just, at what point does it not become reasonable? If that
I mean, it's once he's dead, the intent is for something different. So
it's true, right?
If that's where it triggers up, we'll plead to abuse of the corpse or something.
But I do want to bring up a key objection that the defense did bring up, because I think it's important to note. The defense is saying, well, in most of these cops' lives, which does happen, somebody will be knocked out and then somebody will get a wake up and then want to fight again, right? So they were saying we were holding him down because that was a possibility. He could have possibly woken up and become a threat.
Yes.
That there are two reasons why that is not justified in any type of situation, and usually in law enforcement circles, because there's a difference between threat and risk, right?
Mm-hmm.
But if somebody's a threat. So for instance, if I go to a scene and I got two guys there, right? Those people are threats, right? It's 2-1. But now I can't just take out my gun because they're a threat and say, oh my God, use of force. That doesn't work that way, right? They may be a risk, but they're not a threat. If they're coming out and they're coming out with their hands up and ready to fight, that's a threat, so it's a different. Now, we prepare for risks, but we respond to threats. So when Floyd was down and he's handcuffed, he's sitting down, okay, he is not a threat, he is a risk, and you are not allowed to use force preemptively to turn risk into a threat. That's where I think they get convicted. And that's one thing a lot of people don't understand. Cops always deal with risk and threat. Just because something's a risk doesn't mean it's a threat. You go to jail for responding to risk with force. You stay out of jail by responding to threats with force.
Mm-hmm.
Yeah.
I'm sold.
Yeah. I mean, that's a fantastic explanation and a really great distinction. So let's turn to a few of the super chats. I got my first super chats. Yay!
Yay!
The first one is from my brother. That's okay. It's fine. He's one of my biggest supporters. So how have your opinions changed about the outcome of the trial since it began?
Lots of different ways. The third-degree murder was by far and away the most interesting for me personally, trying to figure out whether it was legally tenable. I concluded no, so it's me versus this prosecutor and the judge apparently,
and the Supreme Court of Minnesota.
So there's some issues, but so it's just been interesting trying to really. Well, it's because when I first started this, I thought the best line of attack was actually going to be on the causality rather than the intent. It's like I thought the best line of attack for the defense was, okay, we did the thing, but it didn't cause the death. Attack it from the causality point of view. But now I'm like, no, that's not the best point of view. It's like, okay, let's try the intent angle. Let's try the how did we perceive the justification elapsing? And I think Nate unfortunately gave really good answers to that question. So but that's, trying to figure out what the best line of argument is has definitely been a factor that's changed for me.
Yeah. How about you, Nate?
Well, for me, I started because don't forget, I've trained in handcuffing. I've trained in handcuffing for law enforcement officers. I've trained law enforcement in handcuffing techniques. I trained in also in defensive tactics, which is ass baton training. So, and I was an officer, and I did use of force. So I have when I saw the incident, I automatically I felt from my own experience that this was unjustified use of force from that beginning. But just because it's an unjustified use of force from where I'm at in New York doesn't mean it is where they're at in Minnesota. True. And so going into the case, I had those preconceived notions that, hey, where I'm from, you just can't do that. Going through it though, understanding that there was some training involved, understanding that there was some murkiness involved, it at least let me open my eyes up to see that, this guy could be found not guilty. If somebody could buy into all this stuff. But I don't think my opinion of what happened has changed. My opinion of legally what's going on has changed. Like, for instance, at first, when I first thought I didn't think second degree murder was good. But then when I found out that felony murder with an underlying felony of an assault is possible, not only is it good, it seems like it's more likely. Matter of fact, it's easier to prove the assault than it is to prove the manslaughter, and it's easier to prove the assault than it is to prove the murder 3. So it's honestly reversed. And I think a lot of people have an issue with that.
Minnesota's weird. Minnesota's weird in its definitions because murder 2 doesn't necessarily include murder 3, and murder 1 doesn't necessarily include murder 2. Some weird definitions over here that we got from. It's like, okay.
But people, I think people fail to realize that assault in a third degree, right? Which this obviously is. I'm not. We don't even have to. He was killed, but you just got to be seriously injured. He was killed, so we have an assault in the third degree. That's easier to prove than the other 2 charges, but it gives you the most time. So a lot of people keep saying, like, I don't think they'll give him murder 2 because, it's so much time. Not understanding that the level of intent that you have to prove for a simple assault is so much lower than a manslaughter charge that I think they had that in spades. They just got to prove an assault. And that shows you, unfortunately, the problem in Minnesota because they got to get the murder doctrine in there.
Yeah, agreed. Because that for me was the biggest change was when I also learned about the felony murder rule, and that was just before trial. But that was mind blowing for me because I remember when you guys were first talking about it, and I was just kind of watching your conversation. I was like, that's not how felony murder works. Like that's not how I mean, and I had to review my bar notes because I was like, wait, is it? Because I don't think so. Like it's been a while since I took the bar exam, but
so it's definitely not. But Minnesota for some reason.
But I mean, yeah, their felony murder rule is wild. So that was
it's saying it, right? It is wild.
It is. And so that for me was like as soon as I did my own research on that and looked up some case law on it, I realized like, okay, so yeah, I mean, no matter what, he's pretty much getting convicted of something, and it's probably, I mean, he has a very high likelihood of getting convicted of felony murder. Just because, I mean,
you just got to prove an assault. That's all you got to do.
And assault, and I think generally speaking, it does have to be. I think it does have to be, within certain circumstances. It has to be a particularly egregious assault. But all they have to do is keep hammering the 9 minutes and 29 seconds or whatever, and and to say that Chauvin had people yelling at him, asking him to take his knee off the neck, asking him to let up, and and he nevertheless persisted. And, so so I think it is one of those circumstances where a jury is likely to say, yeah, this assault was particularly terrible. And, you were slowly sitting on him, putting your knee on his neck and just slowly killing him. It just, I don't know. That's how my opinion kind of really, really solidified for this case.
Well, when I looked at the jury instructions, it's almost a gimme. It's like, did you believe that he did this? Third degree assault. This is, if you believe this, then second degree murder. It's like it's just laid out there for him. And I think if I was Chauvin, that's the charge I'm most concerned about. The manslaughter, I think it's a gimme. I think everybody in here would agree that this was a second degree manslaughter in spades. And I think the third degree murder is a little bit iffy, but it is, it's there. But I think the charge that they got him on is second degree. The third degree assault. I think if they got third degree,
second degree, I think you're right the first time.
No, it's third
degree assault, second degree manslaughter. It's hard to keep all these numbers in check. I'm sorry.
I think they just have it, and that's honestly almost a simple assault, right? So that's the type of assault when I slap you and I cut you and then cut you open. That's assault in the third degree in Minnesota.
So let's do a few more of these super chats. Thank you, Dichi them. And then he's got a question here. So why wouldn't they actually recreate the exact situation? 140-pound police officer, 230-pound suspect, similar positions, duration, etc. Effective? So
they said, two things. Number one, they said that because of the high likelihood that someone could get injured, they would not be able to get it approved, because you can't just do things like that to people. You have to get it approved through certain guidelines or whatever from separate medical boards. So they can't do it in that particular way. And the second is that Floyd was an eggshell plaintiff, right? He was an eggshell. So you have to do it all. Heart disease, this, because don't forget, it's not whether he would have killed anybody. It's whether he would have killed Floyd.
Well, according to the one guy was, so
yeah, but this, Floyd, who seemed like, if you listen to the defense, he was walking on his deathbed. He was falling out any second. He may not have made it out the car.
Right.
So it's a shame, but that's as eggshell as it gets. And unfortunately, he died on himself.
Right. And I think one of the experts, Dr. Thomas, was also talking about studies that have been done in similar situations, but she said that the problem with those studies is that they're in controlled environments, right? Because they have certain doctors and researchers, they have certain ethical standards that they have to meet for any kind of studies. That hasn't always been the case, and there have been controversial studies like the Tuskegee syphilis study, for example, is one huge one that people learn about in health law, and that is one of the big reasons why there are massive ethical laws and standards for these sort of test studies that they have on human beings. So one of the things is that they can only go so far to place human beings in danger, even if they consent to the study. So they have to give them an opportunity to get out at any time. They have to give them, and then create certain sort of limits on the danger to the people. So then, if they're testing also for their psychology, because that can impact their physiology, because what you're thinking when you're in a situation like that can also impact your heart rate, because you have, adrenal responses. That's what a lot of these experts have been talking about, is that, the physiological effects of being in kind of a panic when you're in that kind of a position. And you don't necessarily have those same impacts when you're in that kind of a controlled study, because you can get out of it. So there's also that kind of an issue that it may not be an exact like one-to-one comparison that you can actually apply to this case. So even just for accuracy purposes, it may not be very effective. So yeah, so that's that.
Okay, that was a very detailed answer. Fantastic.
No, thank you. So next super chat, Dogbert, am I a bigger supporter now? I believe so. Yeah, I'll take it. Thank you. So
I saw one question from MI that was interesting because it was a callback. It said, what was the motion to acquit about this morning, just for protocol? Yeah, because both Nate and I were wondering why the defense didn't move to acquit after the prosecution's case rested. And for some reason, I don't understand completely, but the judge said you can make that motion this morning, even though the defense's case had already started. So it's like, we'll consider it as timely now.
Interesting.
Yeah, I don't quite remember why, but that was the reason why, because he didn't want him to make it on Monday or something for some reason. So it's like, okay, you can make it on Wednesday for the
after you put on your two witnesses,
like,
right?
Okay, yeah, so like, okay.
But I go ahead.
That's very kind of the judge, because I know of plenty of judges that'll say, nope, not timely. You can't make that motion now. Bye.
No, it was done in advance.
It was
arranged in advance.
I think one of the witnesses
it
was something weird. But the thing is that the motion was like a 5-minute thing, though, because we all knew that motion was not going to be.
No, never know, man. It could go either way, right?
No. If you're the king, that wasn't going either way. they were going to have to put it in the case, but I think you do it for the record, right? You do it.
You got to put it in. You got to put it in.
So you can have something for appeal.
Yeah, put it in the record.
But otherwise,
just to clarify for anybody that doesn't know exactly what we're talking about. So in any kind of straight from litigation, pre-trial through trial, the defense has multiple opportunities to try to move to either dismiss claims or move to acquit, or so at the point where the prosecution rests, after they've put on their case in chief, they've put on all the evidence that they have, then the defense has the opportunity to say, all right, this is literally everything that they have, and they have this element, this element, this element they have to meet. So evidence has to apply to each and every one of those, and if there's a gap in any one of those, then they should be then the defendant should be acquitted. So there's that opportunity to do that before the defense even has to put on any of their evidence. So typically it's good practice to do it because the defense attorney, if they don't do it, sometimes they can face professional responsibility issues. But also it's just good practice for your client. So yeah, that's just to kind of clarify. Do you guys want to add anything to that? Okay.
No, I think you do. Yeah, you explained it away.
All right. So, okay. So I think, do you got anything else you guys want to talk about with the Chauvin trial? Oh, Daunte Wright. That's another big issue.
Yeah.
The effect that can have on this case potentially on the jury. I know that was an issue earlier this week that defense attorney wanted to try to sequester the jury. The judge ruled against him.
Which I'm really confused about, because number one, this ain't OJ, right? OJ, those jury, they were going away for months. This is Chauvin. We knew this was going to be maybe a month, 5-week trial regularly. So I don't know why you don't sequester this jury for the 5 weeks, right? I don't know why you just don't put them in a hotel room, keep them away from everything, and then let them come to their decision. Now, I understand sometimes when you're sequestering a jury, you get into the we want to get the hell out of here problem. where as soon as they get the case, it's like, yo, who thinks he's guilty? Then you get 5-5, and they're like, I gotta get this is a weekend, it's Friday, we want to get out of here, right? I don't want to see you guys. We've been here for 5 weeks. And that could play bad for justice. So I definitely understand one reason why the judge said, okay, we're not going to do sequestration. But on the other side, I think it would have been better, because then you could really, because it's hard to stay away from media nowadays. They will be sequestered when it goes to them on Monday. The judge said Monday they'll get closings, and then the jury will get it. Then they'll get sequestered. So I think he's trying to do that just so that their deliberations can be a little bit less, a little bit more fruitful. But
as long as we're doing it, why don't we do it real old school, like 18th century style, where no food, no water, you're not even allowed to leave the room until you come to a verdict.
Until you come to the verdict, right? 12 angry men. No, but I think at the end of the day, it's I don't know with this jury, what's going to happen with this jury, but it's going to be interesting, because the things that are happening outside, because for everybody that's the rules for the jury is that they can't watch any coverage about this stuff, so they got to stay away from media and stuff for this.
So that means they're not watching our stream, Nate.
Yes, but for other stuff, though, right? They can watch. So they're watching the Daunte Wright stuff. They're watching the thing in the streets, and that has to have some effect. Where if this is a not guilty verdict, or is the city going to burn down? You know what I'm saying? Is all hell going to break loose? So there are pressures on a jury, and they're human beings just like us. I want to send my kid to school Tuesday, and if I say not guilty, he may not be able to go to school for a week, because all hell's going to break loose.
There's a decent chance the city's going to burn no matter what happens, because this is what we're doing now.
So yeah, that's possible.
Yeah.
So yep. Well, anyway, so do you guys want to move on to the next subject, or?
Oh yeah.
Okay.
Daunte Wright, right?
Yes. Yeah. So what are your thoughts on that in the wake of the Derek Chauvin trial? Obviously, it's a different situation, but it's similar, because we have a police officer that shot a young man at a traffic stop. Apparently, it was an accident, right? Because she thought that she was reaching for her taser, but she reached for her gun.
Now, there's one interesting thing about the whole taser gun thing that I'm just not getting. And I understand why they charged her, because, to be honest with you, if I was a prosecutor, I might have charged her too. In law enforcement, you have your dominant hand and you have your weak hand, right? My weak hand happens to be left. Some people's happens to be right. So with firearms, right, things like that, you put on your dominant side, because when blank hits the fan and you grow, you grabbing your firearm, right? Limited time, and it's a high impact. So when you need to get to that, you need to get to it with accuracy, with precision, with your dominant hand. Your taser goes on the exact opposite, and the reason why, because it feels like a gun. It's got a pistol grip, it's got a trigger. It's very, very, very similar. So you put it on your left side, and usually if you're going to deploy a taser, you're deploying it in less stressful situations. In terms of, it's not a rapid deployment, you can deploy slower, and it's a little bit more forgiving, with the taser. Some people, take it out and switch it, but it's a little bit more thought process. You need to get the gun faster than the taser. So they're always on opposite sides. So if you have 26 years of law enforcement experience and you've been carrying your weapons like this forever, you train at 20, that means 26 in-service trainings. That means you get to requalify for your gun and your taser. 26 of those, right? You're training other officers on the street, right? And gun right, taser left. In a hot situation that comes out like this, you're pulling out your gun. That's where I think they're giving her the culpable negligence. They're saying that someone with that experience, no one with the tasers at, no one with the guns at. Now I believe this was an accident because I think this was just like an oh crap moment, and I'm grabbing whatever I can, and it happened to be a gun, and I'm screaming taser, taser, taser. No, you got a gun in your hand. But I think also in the back, I understand why prosecutors charge, because they're saying that this was this was a mistake that someone with your experience training other officers should not have made. You know what I'm saying? And that's where we're getting to the point at. Now, I don't think they're going to be able to convict her on the second degree murder because I think this was an unfortunate accident. But I think that if what I'm hearing is true, because the rumor is that she carried her taser and gun on the same side, then you break policy, and then you got the conscious disregard, right? Because now you put your gun on the same side. We train you not to do that. So you took a risk and you consciously disregarded the chance and you shot somebody. That's the reason why we tell you not to put it over there. So if that's the case, then I think you got man too. But if that's not the case, then I think you got a mistake. Go ahead, Kurt.
Yeah, the only thing that sort of goes through my mind, and I don't know where it leads in sort of the end conclusion, because, if I were the person who was shot, I'd be pretty obviously pissed, in addition to being dead. So I would, I'd want some justice there. But on the other side of the equation, I think, what does this do for our ability to find people to want to be police officers? Because police, and as Nate well knows, the danger from a routine average traffic stop is not necessarily purely hypothetical. The number of routine average traffic stops that go from 0 to 60 is somewhat incredible. It's a more dangerous situation than you might think if you haven't looked into it a little bit. So I wonder how this kind of decision to charge will influence people's desire to become cops or their willingness to become cops. And I think it's so I don't know what the right answer is here. I don't have any solution. Maybe there isn't one. So I defer to Alita to answer all of our questions. How do we solve the problem, Alita?
Oh, I don't have any of the solutions, I don't think. but I do. It's my understanding also that there's been I don't know about recruitment levels, but I think there's been a larger percentage of police officers that have been taking early retirements and going into other industries over the last few years. And I can imagine it would take a very courageous person right now, I think, to actually want to become a cop, because of all of the issues that have been going on. And I mean, we still need good cops, right? Like we still need good people to be in those roles. And I mean, yeah, I don't know. That's, like I said, I don't have any solutions, I don't think. But one question that I have, I guess, Nate, is how easy do you think it is to? I mean, I have really no frame of reference. How easy do you think it is to when you're getting ready for going on duty to put on your rifle and your gun and your taser on the wrong side? Like maybe you just are having a rush day or something. I don't know. How easy is that? How likely is that? Oh, you're muted.
Yeah, sorry. Some officers, to be honest with you, well, for me, it's a special duty belt that you wear, so you just kind of hang up the duty belt, and it's on, and when you get it, it's already on both sides. Your taser's here and this is here, so it's pretty much all already done. And they had the gun lockers, but it was just it's just here and here.
Yeah.
I would say some officers would keep it on the same side, maybe for preference, if that's the case here. I'm not sure if that's the case here. But from the reports, some reports are coming out that the officer had both taser and firearm on the same side. The problem there is that it breaks policy, and they train you. It's like we're telling you, don't do this, or you might grab the wrong weapon and kill somebody. So if that happened, and then now, guess what? You put them on the same side, and you grab the gun, and someone died. That's a conscious disregard of, it's a reckless conscious disregard of blah, blah, blah. So that's what they call culpable negligence.
Yeah.
That's man too. So
Right.
but again, if it was on the other side, if she was carrying on the right side and she just pulled the wrong weapon, that's different, right? That's different.
Right.
And her screaming, taser, 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 shows that she thought she had a taser in her hand. Now, those facts I think are going to now be important, because again, I think this is going to come down to the violation of policy. If she violated the policy, then she may be going to jail.
Yeah.
That's just the way it works.
Yeah, very true. So one more super chat from my brother again. When this is all over, will the law blogs talk about lobbed bombs or low blows? This is a reference to Arrested Development. Have you guys seen Arrested Development?
I've only seen spattered episodes, so no.
Oh, so there's a character. They have a lot of funny lawyer characters on there. There's one called Bob Loblaw, and he has the Bob Loblaw Law Blog. And then at some point there's an article that headlines Bob Loblaw lobs law bombs. Anyway, so he's making a joke. Thank you, Andy. I love you very much. So anyway, and another one. Cops and teacher equals higher pay and more stringent requirements. Thank you, Dogbert, for that super chat. Yeah, I mean, it's true. Very true. Teachers, of course, are also very much underpaid, and they have incredible work schedules that are just totally grueling. I have teachers in my family. I know exactly what that's like. So yeah. Anyway, anything else you guys want to say about Daunte Wright before we move on?
The one thing I do want to acknowledge is it's now harder to, I think, to have an opinion about these police involved shootings, because every police involved shooting is now turned into some type of race wars scenario, and I do understand that you have to understand the history of the country and going forward, and now where we're at today. But I also think that we kind of have to put some responsibility on both the victim of the violence here and the officer. In the sense of the officer, if she violated training, that's a problem too. But also, this person was resisting arrest, and I think sometimes I feel bad for even mentioning it, but resisting arrest is a dangerous thing, and I think people need to really understand, when the police come and you start resisting arrest, people get hurt. It's not something, this guy didn't deserve to die, but he was resisting arrest, and that is a dangerous thing, because you got these cops who are scared out there, and you got these people out there, and if you just got the handcuffs on, and we wouldn't even know what his name was. There wouldn't be riots in the streets. But this whole I want to fight the cops. We need to understand that is not the right answer anytime. That's going to lead to somebody's death, either yours or the cops. And either way, it's going to be bad for society. So it's just people to stop resisting and just call it a day. You got caught, you got caught.
Yeah. Yeah. That's another good point. And I think right now that's a lot of people will find having responsibility on the victim is distasteful for a lot of people, I think, because of the current political climate. But that is something that people do need to understand, is that the police do have certain authorities and they have certain capabilities that they're able to use force where a normal person cannot legally. So yeah, no, I definitely hear what you're saying.
Yeah, what I'm saying is most of these cases have the same type of chain of events. Somebody who's resisting officers, and next thing you know, somebody gets hurt. Jacob Blake, for instance, he's beating up the officers and got a knife, putting his hand in a car, resisting arrest. Unfortunately, George Floyd, even though I think that's an unusual force, he was resisting arrest, and this kid, he happened to be resisting arrest. So it's always ending up bad. But now it's when we don't want to get to the point where we start saying resisting arrest is okay, as long as the cops don't kill you. The resisting arrest part isn't okay either. It's just that now, we're so focused on the end result, we're not understanding the cause. And the cause, in most of these cases, these people would not have died if they did not resist. It's a cold thing to say, but it just happens to facts in the logical chain of events. You don't resist, you don't get harmed. But that doesn't mean you should be killed. But we got to understand there's a chain here that can be broken. It can be broken by telling people to stop resisting, and it can be broken by retraining officers.
Yeah. So, all right, then I guess we'll move on to the next subject. If you guys are cool with that?
Sure.
So did you guys want to talk about the new YouTube video that came up?
I would love to talk about the new YouTube video. I have not seen the new YouTube video, but Nate has previewed it for us. I want to learn how we're all host. So yes, let's have the how we're host discussion.
All right. Yeah, Nate, you shared this with us. So
yes.
why don't you set the stage?
I'll set it up. All right.
Yeah.
So YouTube, well, obviously, as all of us know, YouTube is a private company, and we don't have any free speech rights to YouTube. But YouTube has given us guidelines that if you work within these guidelines, your videos won't be removed, you won't be demonetized, right? As long as you fit within these guidelines, you won't be kicked off the platform, anything like that, right? Well, YouTube just wants to make it clear that those guidelines are just guidelines. That even if you don't break any of those rules, they can still kick you off. They can do whatever they want, because if you may not represent what YouTube may want to represent. So this video is going to just explain to the point that all the rules and stuff that they have up now mean nothing, because they can kick you off whenever they want. Play the clip.
All right. Let's see here. How do I? Sorry.
All right. So go down with this share plus. Okay.
Okay. Sorry. First live stream. Let me figure this out. Share plus.
And
share
then
screen.
Your screen.
Got
you
it.
have the video up already? Go to Chrome
yes,
tab.
I do.
Oh, you see where it says Chrome tab?
Yes. Sorry, guys.
And then click where the video
Chrome
is.
tab. This one. Here we go. Okay.
And did you share audio?
Sorry. I don't know. Let me see here.
So click the share screen again.
Okay. Sorry,
turn on.
guys. Share screen. Stop screen. Do that?
Yeah, stop share screen.
Okay.
Now
Okay.
do it again. Share screen.
Okay, share screen.
Now, but when the first dialog box comes up on the bottom left-hand corner, it should say share audio.
Okay. Okay, share audio on the next. Okay. Thank you for that. Okay.
Then go to
Got
the
it.
Chrome tab and then do it.
Got it. Okay. You guys see it?
Yes.
Yep.
Got it.
True or false? A creator can get demonetized or suspended from YouTube even though their videos didn't break community guidelines. What do you think? If you said true, you're right. And although it's rare, you may have seen it happen in recent years. In this video, I want to tell you about YouTube's Creator Responsibility Initiative, something you may have seen in the news but not fully understood. First, for some background, as a YouTube creator, you're sometimes seen as a representative of the platform and a member of this giant influential community. The more popular you get, the more you're probably called a YouTuber, and the more you help represent the whole global community of creators. Not to mention, you're probably admired by many smaller creators who would love to achieve your level of success. So, not to sound all dad-like here, but you might say that with great popularity comes great responsibility. It becomes your responsibility, along with every YouTube creator, to help us keep the ecosystem healthy. Now, if the things you do and say as such a representative are really reckless, dangerous, inappropriate, on video or not, you can actually cause damage to YouTube and its millions of creators by hurting their reputation and revenue. Why? Because YouTube and advertisers don't want to be associated with that level of craziness. And when advertisers pull their spend, everybody loses. That's why YouTube has this Creator Responsibility Initiative, where even if a creator's videos don't explicitly violate the community guidelines, there's a whole team of experts who weigh in on whether action is taken on a channel. And the penalties can include demonetization of a channel temporarily or permanently. This means a creator can still upload but can't make any ad revenue. It can include restriction of videos in YouTube recommendations, like on the homepage, trending tab, and or the watch next section. and even loss of support from that creator's partner manager. Now, again, these situations are rare and often temporary. Privileges are usually given back after a period of time and good behavior. So that's how it works, and I hope this helps explain some of the headlines you see occasionally. If this would never be an issue for you, thanks for being a great representative of YouTube and its creators.
Okay.
I really wish someone had bought me dinner first.
Oh man.
Yeah, so YouTube is making sure that you don't. Matter of fact, whatever you do doesn't have to be on video, right?
Yeah, that was my
It's your
personal favorite
life.
part. That was my personal favorite part. On or off platform, anywhere.
Yeah. Suddenly we're agents of YouTube.
Okay. I mean, okay. What percentage of people out there think that people who are on YouTube, like independent creators, are in some sense speaking for YouTube? Is this a thing? Do people think that these independent creators are speaking for YouTube? I didn't think this was a thing.
To be fair, they're saying that we are representing the YouTube brand, quote unquote.
No, I'm not. Am I?
You're on YouTube, right? Are you a YouTuber? Remember, he said if you're a YouTuber.
I think he said there's some sort of minimum threshold he applied that when I reach a big enough number, maybe I'll be called a YouTuber. I mean, I don't know if I'm in that category yet. Is that a different button? I don't know.
So, I mean, what I'm thinking of is I'm trying to figure out, it's like they're trying to have the benefits of an agency relationship without any of the responsibilities of being a principal.
I think what they're doing is making our relationship with YouTube more transactional in the sense of you upload to us, but we just did. In other words, you can follow all the rules, right? That's what they're saying. You can follow all the rules, and we can still demonetize you, remove you from the platform, the whole nine. So the rules mean something up to a certain point. I think it almost is like the rules are an excuse, but at the end of the day, you can be kicked off for things that you don't even do on YouTube. That's what he's saying. You can be kicked off the platform for things that you don't even do on YouTube. Think about that.
Yeah.
I object to the background music in that video.
It's very YouTube. So, I mean, it's problematic because it also seems so sometimes, when I'm also thinking about the fact that like when someone takes a certain protective action, kind of like the Streisand effect, that's for some reason that pops into my head. You take a certain action trying to protect information or trying to protect a certain position. And then ironically, you end up actually creating the exact opposite result than what you wanted. It seems like what they're trying to do is to create a space that they can sort of protect YouTube. But at the same time, it seems like unintentionally what they're going to end up doing is making it seem like they are then endorsing all of the voices that are on YouTube. So that makes it seem like, there's a lot of different, I mean, yes, there's people on the right say that conservative voices tend to be pressed down, pressed out, that kind of thing, but they still do exist on YouTube, right?
I know what right-wing media is talking about tomorrow. It's like, I know what Ben Shapiro and Crowder will be talking about tomorrow. Pretty confident over here.
Yep. So, but I don't know, but I mean, it seems like, it would seem then that moving forward, any voices that continue on YouTube are expressly allowed by YouTube. So I don't know if that means that's going to be that they're going to start really cracking down on these different political voices or other things in that nature. I don't know, but let me see a couple super chats on this. So John O'Brien, thank you for the super chat. So you are all employees with a silent morals clause, contract be darned. So this does not make us employees because I mean it would kind of feels a little bit like it. Like I said, that there's like a pseudo agency relationship here, which is like I said, it's like they get the benefits of an agency relationship, but none of the responsibilities that a normal principal would have. For example, none of us get any kind of benefits that an employee would get. Certainly not under California law, which is where, really what affects most of these tech companies, these social media companies. But yeah, it definitely feels like a weird sort of employment relationship that they're trying to create. What do you guys say about that?
I'm very uncomfortable with the whole thing. One of the other things I noticed too was they said, I think I got this correct, where they say it's only a small fraction of creators who will be impacted. And I'm thinking to myself, okay, how small a fraction? Because I'm not sure how much I care. Because if we're talking about 1% or 0.1% or 0.01% or 0.001%, we're still talking about a lot of people. There's a lot of content on YouTube.
That's
so it's
true.
like, oh, this is only a small amount of creators. It's only one in 100,000. I'm like, well, I don't know how much better I feel about that, to be quite honest.
Right. You're right. And particularly because, it's not entirely clear exactly what YouTube thinks that their image is or should be. That hasn't exactly been clear. So it's, even from a creator standpoint, if you're trying to stay within their concept of what's in and what's out, it's hard to do that if you don't really know what to compare yourself to.
Especially since the entire point of this is assuming that you are within the guidelines, assuming that you are within our terms of service. That's the entire premise, right? It's like, even if you're within our terms of service, even if you're within our guidelines, we can still demonetize you, and we can still remove you from the platform, all stuff, which kind of definitionally means that there's no term, no service, no guidance. Yeah. Because if there was, it would be in the terms of service or the guidance, right? Yeah. So it definitionally, inherently means it is and always must be an ill-defined space that you have to guess at. What fun.
Yeah.
We can all just make guesses together. That's great. So it's no longer, let's look at this language and interpret this, which is already so vague, it can mean anything I want to mean anyway. But because it's vague enough, this super vague language was somehow not vague enough, let's just make it, we're not even going to speak about it anymore. It's just whatever we think it is. Hopefully you know what that is.
Yeah. Oh, Nate, you're muted.
I'm doing it to myself a lot. I think you guys are missing a very important point here.
Oh dear.
If what both of you are saying are true, how does this, because Alita, you were saying that they're tacitly saying what we have on here, we're authorizing, right? This is our viewpoint, right? And if anything is not consistent with this, you can't be on here, right? With our brand and our viewpoint.
Right.
How does that not violate 230? Only reason why I'm saying that is because doesn't this make them almost the publisher, right? If you're now sanitizing content, right, to say we don't allow this content or we don't allow, and because the whole umbrella of 230 goes under, you can have these terms of service, and as long as people follow these terms of service, you can, 230 protects you. But now they're tacitly saying the terms of service don't really matter. We can pick and choose who we want on the platform or not. If you're doing that, you go from platform to publisher under 230 and can be held liable under 230, right? For things on your platform.
I don't know about that, because Section 230 is very broadly written, right? Because they say that they have the ability to kind of maintain their platforms, by getting rid of any content or moderating any content that is, offensive, hateful, damaging, defamatory, whatever, or otherwise objectionable. It's that phrase, otherwise objectionable, that really means pretty much, I mean, it's so subjective, right? It just has to be objectionable to whom? To someone, right? To anyone, to YouTube. So, I mean, they can just use that phrase right there and just say, well, your video, your entire channel was otherwise objectionable to us. So,
but that's not. But in that video, they're saying that me going out on a date instead of having a bad date can otherwise be so bad that they can kick me off the platform. You know what I'm saying? So even under this, right? Even under this umbrella, they are technically publishing now, right? If they were a platform, it'd be anybody can come on. Here's the terms of service. Anybody who violates that is off. Then I'm not publishing. But now by saying I can take bits and pieces off at will, based on not only what they
Yeah.
put on the platform, but what they do in their personal life.
Yeah,
How is that not publishing now?
Twitch is doing the same thing. I realized over the last week. I think they just announced a very similar thing, that they made a statement saying that they can take down a Twitch platform.
Yes, you're right. That's right.
Just exclusively because of something that someone did outside of the platform. But here's another super chat. This is interesting. Pretty sure this video is in direct response to David Dobrik. Thoughts? And that could be right. So for anyone that doesn't know, David Dobrik is a super famous YouTuber. If you don't know, then maybe he's not that famous, but he's famous on YouTube. You know, he's got millions of subscribers. He's part of the Vlog Squad. That's like this rotating door of YouTube creators that kind of I think most of them started on Vine, and when Vine closed down, they came over to YouTube. There have been a number of scandals around David Dobrik over the last month or so, ranging from, bullying other Vlog Squad members, bullying other members because of their, I think there's one that has a disability or something like that, and he was like using that disability or something. And then there's also the Dom Zeglaitis, Dominika Zeglaitis, if you want to say it in Lithuanian. That's my background. That's why I'm saying it like that. But Dirty Dom. So there was an allegation of rape against him by a woman that was part of a video that became a Vlog Squad video. And apparently it was during the filming of that she allegedly was raped. And so since then, Dirty Dom and I think David Dobrik as well, both of their channels have been completely demonetized by YouTube. So technically that was, something that happened entirely off the platform, but even those are still connected to activities on the platform, right? Because that video that the allegation against Dirty Dom, came from, it was in the process of creating a particular video that was subsequently taken down. So I don't know. What do you guys think though?
Well, first thing you said is something that happened off platform, and we don't even know that. Something might have happened off platform because it's an allegation. So there's that. Forgive
me. Thank you for clarifying.
I wasn't really so much trying to correct you as I was trying to correct YouTube at that moment. But the other thing that sort of, I'm a bit of a cynic on this one. I do not believe that these measures are being taken because of the incidences that you just described. I think the incidences that you just described and the more horrific instances are the Trojan horse for the real policy. And the real policy is the real thing that YouTube seems to be moving towards is not even getting rid of conservative voices, but getting rid of independent voices. They seem to want to move to a situation where they are hosting more traditional mainstream media content. ABC, NBC, CBS, Fox, Disney, so forth and so on. Big players that produce content that people like and are good sources of revenue, not to mention the companies themselves, of course, have big checkbooks. So that's super helpful. So I don't really believe this is about David Dobrik. I wouldn't even believe it if they said it overtly. I'd be like, I don't believe you. I think you're lying. I think this is meant to go after voices you don't like, voices that are in line with your alignment, small voices, towards an ultimate end of homogeny of viewpoint / the corporatist speech, and YouTube being different. So that's what I think is going on. But then again, I'm a cynic. So
that's definitely possible. I mean, and especially when you consider that it's also happening on Twitch as well. And I don't know if I don't think any of these creators are on Twitch either. So I first heard about it on Twitch, now hearing about it on YouTube. I wouldn't be surprised if we start hearing the same thing from other major social media platforms. But it definitely is concerning. So anyway, any other thoughts on that?
No, except, we're living in a new police state.
I think I need to rethink my content.
Yeah, it definitely is concerning. So
maybe only cover cases in which NBC, CBS et al. Win. Maybe I can do those legal cases.
Sometimes it all depends on what you cover, because I did the case, the Hunter Biden laptop video. I did that video. Every video after that has been demonetized. soon as I upload.
Really?
Before it was like, maybe once in a while. Now it's like I've done 4 videos after that. Each one of them have been demonetized. Unbelievable. But I it's just they want, they know what they're doing. So and I liked there was one channel. I forget the name of the channel. It's one of those children's channels. It got like 5 million subs. And I like what the guy said. He said, you know what? We had to stop fighting with YouTube and just treat YouTube as our boss. You want to do this, you want to do that. And I know it's sick, and I know people are like, I want you to fight the power. But at the end of the day, if you want to grow on the platform and you want to be successful, you got to play by the rules. If they're the boss, they're the boss. So it is just what it is.
Right. So, okay, well, I think unless we want to keep talking, I think that probably is about it for tonight.
Well, I had fun.
Yeah, thanks so much for
fun. This was great.
Yeah, I'm so excited. Yay, first live stream. minus a few little details there, but we got through it. Thank you, Nate, for helping me. So I had a fantastic time. Thanks so much to both Nate and Kurt for joining me, and thank you to everyone that's been following along with us and commenting and all the super chats and everything. Super appreciate it. This has been fantastic. So with that, I guess that's about it. We can end with a pose. Okay,
Gotta hit the button now.
Okay, bye.